Welcome to another episode of Outer Temple Chambers Travel Talks. Today's focus is on personal injury damages in the Netherlands, Spain and France. And I am very pleased once again to be joined by Gerben Janson, Anna Romero and Thomas Ricard. Okay, so moving on to what specific injuries or pain or levels of inconvenience that can be compensated for. Of course, in England, we look at the matter quite holistically. We look at the diagnosis and then the prognosis, and there's not any distinction between permanent injury and temporary injury. But Anna, there is that kind of distinction under the Baremo, isn't there? How does that work?
Yes, exactly. And so the Baremo reflects, on the one hand, the period during the victim undergoes medical treatment intended to achieve the consolidation point that we were mentioning before. And then, on the other hand, there would be a compensation for the permanent symptoms. So not for the injury itself, but for whatever permanent symptoms the victim is left with once the medical treatment has finished or the injury has stabilized. So we have this distinction, and both heads of laws receive different treatment. On the one hand, the period of temporary incapacity will reflect different categories depending on the impairment that the victim has during that period. So there will be a different compensation for the days during which the victim is fully incapacitated because of being in hospital, for example, or during the days that the victim is unable to resume day-to-day activities, not only professional activities, but any day-to-day activities that the victim was carrying out before the accident. And then there will be another category, which would be the days during which the victim is still receiving active medical treatment, but is able to do some of the day-to-day activities. So each of those categories has an award on damages, which is calculated per day. So each day under the different category will receive a different compensation, and one we would need to assess. Once the victim has reached a point of consolidation, we would need to assess how many days under each category the victim would have endured, and so in order to calculate how the damages would be awarded for that period of temporary incapacity. And thereafter, what we will look at is what, if any, what permanent symptoms the victim may have been left with. So what sequela the victim will be suffering from permanently. And this sequela falls under a listing that the Baremo contains, which gives a number of points for each type of sequela, and depending on the severity of the permanent symptoms, the victim will be awarded X number of points for each sequela. There's a complex number of rules to how to apply this assessment, because the Baremo talks about concurrent sequela, about different situations that we need to be analyzed. But eventually we will come out with a number of points which is intended to reflect the severity of the permanent symptoms the victim is suffering from. And that number of points will then have to be assessed in accordance with the victim's age at the time of the accident. And the Baremo gives us a long listing of tables with referring to the victim's age and the number of points, which at the end comes out with a specific figure in euros, which is the award for permanent symptoms. So that's broadly how it would work. On top of that, there are other heads of laws which are also intended to compensate the victim's pain and suffering, and that would be, for example, the permanent incapacity, which it is regarded as primarily compensating moral damages because of the of the permanent incapacity that the victim has to carry out day-to-day activities. And there are other heads of laws under the Bible, for example, compensation to family members that have to help the victim during the period of healing, and these are all also intended to compensate pain and suffering.
Thanks, Anna. Just so we're just being absolutely clear, of course, there's been 2 Baremo systems. At the moment, we're talking about the most recent Baremo. When did the most recent Baremo come into force?
So that's exactly the case. We have, at the moment, it's true that we have 2 systems that are applying to victims of road traffic accidents. We have the most recent Baremo, which applies to accidents occurring after the 1st January 2016. So anything that comes out, any accident, road traffic accident occurring after that date will fall under this regulation. But for victims of accidents occurring before that date, we will still have to apply the old rules, which, I mean, there's still the distinction between temporary incapacity and permanent injuries and permanent incapacity and so on. But it's the
levels of compensation are a little less generous and variety there, aren't there?
It's more sophisticated in terms of the rules that have to apply, and as we were referring to the context of the victim in which the injuries have to be assessed and so on. They have points in common because at the end of the day they come out of common roots, and common principles, but they are different and they need to be applied differently. So this cut-off date, the 1st January 2016, is what guide us in terms of which Baremo we need to apply. But this is for road traffic accidents, and we should bear in mind that for non-road traffic accidents, the Baremo is not a compulsory rule. So there are strong arguments to support the fact that they need to compensate the victims' injuries, which obviously would be the current Baremo, even if an accident has occurred before January 2016. This would be outside road traffic accidents, where we can build up an argument to say that at the end of the day, because it's not a compulsory norm, we can work around it and to make sure that the victim receives the best or the most accurate damages to compensate his situation.
Thomas, is the situation similar in France between permanent and temporary injuries?
Yes, it's very similar, and without going into a sort of a copy and paste of what Anna said, I would just, which was very clear. I think there is just 2 comments which I think are to be kept in mind. The first one is we've got what's called the permanent functional deficit, which is an analysis of how impacted you are in the long term. It's going to be a percentage, which, like for Spain, which be applied depending on the age of the claimant at the time of consolidation, and which will lead to a level of compensation. Interestingly, the way the disability is assessed is very different from what's going on in the UK. It is very different, and we noted this as the consequences of the Wall Mutual de Poitiers decision, is by asking UK medical experts to conduct the same analysis. And even though we translated the whole paperwork, the analysis is substantially different. I'm not talking about simple cases, I'm talking about complex traumatic cases. And that's been a source of concern. I know the case law hasn't changed, but we see, I would say in practice, a rather different approach, because we whether you're on the insurer side or on the claimant side, I think there is, for those complex cases, a concern to get the right picture. The second comment I have is, and it's sometimes badly understood, particularly by claimants, this permanent functional deficit has sometimes got no relationship with the gravity of the trauma. If you recovered perfectly well, your permanent functional deficit will be almost nil. So it can be quite traumatic. For example, you can have a double fracture of each leg. Some people actually recover really, really well. And 2 years later, they got no signs of the index accidents. So in the case like that, you're going to have a rather important compensation for the period up to consolidation. But after consolidation, you're going to have to actually have a more pragmatic approach and see whether something actually really impacting you in the long term will be characterized. So that's those two comments that I had, which is the need for a nuanced approach, and the fact that this principle has got no relation with the gravity of itself of the event. You need to look at the long-term consequences. It's something that needs to be explained, because it is sometimes a source of frustration for a victim who thinks they're entitled to a lot of compensation, while actually, according to French law, no. And French law is much more generous with respect to some other heads of loss, such as moral damages. We may come back to that later on, but that's the second point I wanted to underline.
You raised the point of medical evidence, and of course, we know under the Rome II laws that are applied that there's a distinction between the substantive law and procedural law. And you mentioned Wall and Mutuel, which is the key English case on that point, whereby the English courts have said, well, we'll adopt our own procedure with regards to the obtaining of medical evidence and the presentation of it, but they're still stuck with the position that they've got to apply French law, Dutch law, Spanish law to quantify it. You'll have been, I'm sure, in many situations, Thomas, where you've been sent through, say, in a serious injury case, 4, 5, maybe more medical reports, and you're asked, what's it worth? Is it that simple?
Obviously, no. I think there would be two things to do. The first thing is to understand that I think it's not up to the lawyer to put a figure. That's wrong. We're here to provide guidance to the court. The second is to ensure that, for example, if you've got several medical examinations by UK doctors and you've got a French medical expert who's appointed by the party, you need to ensure that he can do his job properly. You need to ensure that he can go and see the victim if he needs to. Obviously, the lockdown has impacted on that, but we still have a French doctor who can go to London. So it's about anticipating those sort of things, because you might end up in a frustrating situation for claimants, for the insurers, and for the lawyers, for the experts as well. So it's not that simple. But
why is it important, Thomas, to sometimes get that French lawyer in? Is it because you have that system of ratings of disability under French law, which are not automatic, won't be understood, for example, by an English medic, and it therefore doesn't neatly fall within a category under the French system?
Exactly. You've got the French experts who are appointed by the court in France, have a special training for this rating. So in a better world, UK doctors would follow that training. What we try to do is provide them with the sort of textbook to help them. But again, I think that with some complex accidents, you need to be a bit careful. And it's about anticipating that to make sure you've got court's permission where needed. Conversely, you don't want your valuation set in stone by a French expert who hasn't got the full picture, who's maybe not used to review so many reports as a UK expert would. It's a different approach, so I think it's about finding a balance, making sure you've got the right people on the French side, and making sure your view is not set in stone by these French experts, who might sometimes be used to a rather more narrow approach. The typical example is you're going to have occupational report, behavioral report, employment reports, which are not something that we have in every case in France. A less sophisticated approach on the French side this time, I would say, which might explain the need to be rather cautious and proactive.
Just one final thought, just in terms of France, before we then move on to the Netherlands. Do you think it's a good idea that when the medical expert is first being instructed by a claimant, say for an orthopedic injury, when they're being instructed, the solicitor has already spoken to somebody like you, Thomas, to have in mind what kind of things that expert should be looking at so it's compatible with French law?
I wouldn't go as far as contacting us to know what he would be looking at, because I think in a solution like that, he would probably need to talk to a French medical expert. However, getting a sort of first view on how best we could guide the court, because when intervening as expert, we're not here to provide our opinion, to give guidance. I think getting a quick call to see that type of evidence, I see there's a psychiatric damage, I see there's actually rather complex, how best to tackle that and get the proper evidence at an early stage. Similarly to some of the aspects we discussed in previous conference about getting the right evidence if there is a criminal proceedings ongoing, or getting the proper expert evidence from the police report after the accident. Similarly, getting us on board at the beginning, even if that means not working and not intervening in a case for a year, it's fine, but at least I think we will get on the right foot. And interestingly, and I'll conclude with this, it's been rather useful in the last few years to see more and more barristers being kept in the loop. And you are one of the symptoms or one of the consequences of that, but something that is useful because solicitors understood that actually it facilitates the exchange.
I agree. Gerben, in the Netherlands, is there a special need to involve, well, when you're being asked to value a case, are you okay just using the English medical reports, or do you sometimes require additional information as well?
Well, what we need for medical reports is, we need the percentage of functional impairment is important for us, and we also need to know whether there is a possible aggravement of the injuries. For example, with regards to bone fractures, that there is a risk to that the injuries become worse in the future. And if you know that, then you can have that incalculated with regards to your settlement. For example, make a reservation in the settlement with regards to that possible risk in the future. And when that happens, you can come back to the case and ask everything, all the extra damages that have been caused by the aggravation are possible damages that you can claim then as well. So that's one of the two aspects that we would like to ask for medical experts. One very important thing on the Dutch law with regards to general damages is that you have to notify the liable person or its insurer that you are claiming the general damages. It's a one line, it's one sentence, but if you haven't done that and somebody dies, it doesn't matter because of what, then you're not entitled to the general damages. So what Dutch lawyers usually do is when they get a case and they send the email out that they hold them liable, they will always say that they're claiming the material damages, but also the general damages. And it's a risk if you haven't used that one sentence, then somebody dies, it doesn't matter because of what, then you're not entitled to the general damages, which is a risk here in the Netherlands. What we do have since the 1st of January 2019 that we didn't have before, that all the other countries did have, is that we have bereavement damages now here in the Netherlands. And those bereavement damages are a maximized form of general damages for usually the wife and the other close family related, but it's maximized but before January the 1st 2019, when somebody, for example, it's only in two cases, when somebody dies or when there is a very, very serious form of injury, they state that you should have injuries above 70% of functional impairment, which is here in the Netherlands is just about the maximum that you can get with regards to injuries. In those two cases, then the family members under circumstances can get the bereavement damages, which are maximized, I believe, up to 25,000 euros. But before that, when there is a death case, the family couldn't get any form of general damages. But we do have that nowadays, and we're moving on in the world with regards to that. And the last remark I have is that the general damage here in the Netherlands are legally constructed so that they have been taken care of exactly when the accident happens. So also legal interest with regards to the general damages are calculated from the date of the accident, especially when you have very old cases, 5 or 10 years old, and not a lot of general damages have been advance paid in the case, then the legal interest can get quite high with regards to that. Not in the last 5 years, because the legal interest here has been very, very low, but in very old cases it could still amount to quite a lot.
You spoke about functional impairment and relating to a percentage. You've got a medical report through, say, a relatively straightforward case from an orthopedic surgeon, ankle fracture, was in plaster for so long, able to weight bear within a certain period of time, but is going to always be left with a bit of a limp, might need some surgery in the future, maybe ankle fusion surgery. Would you just be able to look at that report yourself as a lawyer and be able to work out what the functional impairment percentages are? Or would you need the input of a Dutch lawyer or some other kind of specialist to be able to assess what that functional impairment percentage is?
Well, the percentage of functional impairment are not calculated by me, but I would always ask my medical advisor, but that can be, that's a very easy advice for a medical advisor to make. But I have to strengthen that the percentage of functional impairment is only one aspect of the case. For example, if I have somebody that's 10% functional impairment, but they can still do their job and try to move on with their life, then it's a whole kind of different general damages than if it's 10% that somebody's whole life ends and they can't work anymore. For example, if you lose a finger and I'm a top pianist, which I'm not, and my life is in ruins, then it's the same percentage, but it's not the same height of general damage. You still have to look for the specifics of the case.
So is there specific guidance as to what amounts to a certain level of functional impairment, that, for example, that information could be given to the consultant orthopedic surgeon so they could then make that assessment?
Well, here in the Netherlands, they tend to use the AMA guides as the Bible to assess the functional impairments. So you could simply ask the English expert as well to use the AMA guide and to use that as a guideline to establish that percentage. Yes.
So that's relatively straightforward, as opposed to, as Thomas was describing, of needing a specialist expert to fill the shoes to determine the extent of the injury for legal purposes. Yes,
for us, the advantage of the system is that you have a lot of flexibility. The disadvantage is that it's very unpredictable what the height of general damages will be. There would always be quite a large section where you will end up in discussion with the insurer. Yes.
And I suppose that when your advice is being sought, perhaps when an offer of settlement has been made in an English case, it's going to make it a little bit more difficult for you to be able to advise with certainty if the offer's a good one or not, because of that width of discretion.
Absolutely, yeah. And with regards to the general damages, it's not an exact science here in the Netherlands. You will always have a system in which you use it should be at least this and a maximum this. And somewhere within that range, you have to find each other, and otherwise you will have the judge to decide, which will likely be lower than what you can get with regards to negotiations.
It sounds like there's more similarities between English and Dutch law, and more similarities between French and Spanish law. here. So moving on to Spain. Anna, you were discussing beforehand with regards to, for example, with temporary injury, you've got that daily rate for different types of severity of injury. And you've got the point system when you've got the permanent sequelae. If you're just given that pile of medical reports from a collection of maybe orthopedic psychiatrist, neurologist, or whatever in a case governed by Spanish law, but being heard in England, can you just value the case, or are there situations where you would want a Spanish doctor conversant with the hierarchy of different types of injuries and classifications to assist you with the valuing of the case?
I think, as you were pointing out, the situation would be very similar as to what Thomas was describing. So we, as lawyers, we will be providing guidance, and really, because at the end of the day, the baremo is a medical legal system. So it's a combination of medical and legal criteria. So we can go into assessing, and giving a guidance as to what we think would be the appropriate category of permanent symptom that would fall, that a permanent symptom would fall into, or how long the period of temporary incapacity would be for that victim. But it's true that at the end of the day, this is a medical criteria, and depending on the extent of detail that the medical legal reports from the UK experts provide, it may be easier or not to reach such conclusions. But at the end of the day, we are providing guidance. We are not doctors, and we need to be guided by doctors. And in this case, it will be the UK experts. And depending on how far in their reports they go into detailing this criteria, we would be able to translate that into the baremo. But the baremo does not only refer to that; it refers to a whole list of legal criteria that will also need to be taken into account. So it's true that it's a complex exercise. It's a complex exercise which I think will need both the medical advice and the lawyer's advice, because we need to combine all that information to make sure that it is translated in the right sense for the English judge to be able to finally assess damages in accordance with the foreign law.
So does it sometimes depend upon that quality of the English medical evidence as to whether or not it's an exercise that, for example, you or one of your colleagues would be able to say, I would advise the parameters of the value of the case is going to be worth between A and B, or if perhaps the quality of the evidence isn't quite clear enough, you may say, actually, the English medical expert needs to look at these factors to assist me and the court, or in fact, there might be a situation where It might be appropriate for a Spanish medic who's familiar with that system to be involved. It just maybe depends on the quality of the evidence and the complexity of the case.
Exactly. That's exactly the case, yeah.
But the thing that I've certainly taken from this is we clearly need to pay attention to the detail, appreciate the complexity, and learn, even if perhaps we don't go quite so far as spending a couple of days living with our clients. But thank you very much once again to Thomas, Anna, and Gerben. We've been a little bit longer in this podcast or vlog as we have done previously, but just goes to show, because of the complexity and the differences between these issues, we thought we'd spend a little bit more time focusing on them. Thank you very much, everybody, and I hope we can do this again.